Our chief is, as you can see, joining us online, but he's asked to conduct the meetings. Thank you for making time to be here. We know it's a busy time. With that, for a motion on the minutes.
I'll move to the minutes.
Second.
Any discussion? Seeing none, any abstentions or nay votes? Seeing none, passes. I think everything that would be in the chair's report is going to be otherwise discussed, and can turn over to.
Okay, thank you. We continue to work on your budget priorities. You may have seen that there's been a couple of articles recently saying that revenue projections are actually looking up. That is encouraging. There's still a $300 to $400 million gap that the legislature has to fund. And that gap comes from federal legislation that created some shortfalls. The good news is that where we thought there might be very significant revenue shortfalls, it looks like that's hopefully not going to be the case. Legislature is still indicating that state agencies and the judiciary should still look for some cost reductions to take place. In transition quickly to that, we started the legislative session. We, like all the executive branch entities, were told to prepare a 5% budget cut plan. We prepared a budget proposal. It was significantly different from the one that the legislature staff had prepared. That one did include some personnel cuts. As we spoke with individual members of our budget appropriations subcommittee, those members expressed support for our request to not cut our staff. As we explained to them how devastating such a cut would be, they seemed to understand that and appreciate it. And in fact, the chairs of our budget appropriations subcommittee took those particular recommendations off the table for their discussion. And that was appreciated. The budget appropriations subcommittee, like always, prioritized all of the budget requests that were submitted to it, either by the judiciary or the state executive branch entities that report to it, or by individual legislators. There were about 50 of those budget requests. Our request for compensation for courthouse personnel was ranked number 3 overall out of those 50. That's where it was last year. That's very encouraging. I still don't know how far money is going to go. As you'll remember, last year it was ranked number 3, and we did not receive allocations for that budget item in particular. This year continues to be ranked number 3. As you know, there have been some resources that have already been dedicated to the judiciary by way of Bill 134, which was the new judicial officers. That adds 2 justices to the Supreme Court, 2 judges to the Court of Appeals, and a district court judge in each of the 3rd, 4th, and 5th districts. Those officers also come with the necessary personnel. So we do anticipate those will be fully funded. Don't know how much additional funding there will be. I'm pleased that there continues to be some measure of support for the compensation. So that translates to appropriations. Where there might be some reductions in our budget, I think they'll be fine, and I think we'll be able to handle all of those. The vast majority of those will actually be offset through revenue increases, through filing fee increases. This is the plan. This has not been finalized, but it's the plan going forward. So it looks like make up for what would otherwise be more significant budget cuts by increasing few of the filing fees. This, just so you know, this means that that report that the legislature has been requiring from you for the last few years, where we analyze every one of the fees that is charged by the judiciary, is meaningful. It is that report that led us to recommend a handful of the fees be increased, and we were able to go to the legislature and say, because of the report that you asked us to prepare, we know that the following fees are particularly underfunding. We are not suggesting that those fees be raised to fully cover cost of services, because that's not the case with just about any of our fees. And we're not necessarily suggesting it should be the case, but we were able to point out those where the gap was the biggest, and the budget subcommittee seemed to appreciate that and willing to support those proposals that we made wherever possible to offset those decreasing revenues with increases in those handful of filing fees. So that is kind of a long way of saying we still don't know exactly where we're at. Consensus revenue numbers have yet to officially be adopted. That could happen any day now. But I think we're in a pretty good spot overall when it comes to budget. So we've now met with all the members of our appropriations subcommittee. We've met with just about a member of the executive appropriations committee. And there is, at the very least, understanding being expressed for why that core house compensation is a priority. I think that's really it. It's been where most of my efforts have been spent the past few weeks. We are in the final 2 weeks of the legislative session.
When Senate Bill 134 essentially overtook Senator Weimer's bill, judicial officers, Senator Weimer made a statement to the effect he was still seeking funding for a commissioner position on the queue. Has there been
There's not been any further action. We know that he continues to talk about that, and there's another legislator, Representative Oxier, whose House district includes parts of 3 judicial districts, and she went to each of those meetings to which she was invited over the summer and fall without anybody asking her to. She also submitted a request for appropriation and asked for two commissioners, because she had heard at those meetings that that was something that was needed. So a couple things about that. One, I very much appreciate, first of all, that she went to 3 of those meetings where legislators and judges had an opportunity to visit with one another, and 2, listened, heard some of our needs, and independently went and asked the legislature to fund some of those. So there are, on 2 different fronts, those requests for commissioners that are still advancing, have not been resolved. I don't know how likely it is.
I know that that's a general budget thing, and so that if they gave that, they'd probably take away somewhere else. I assume that's in the mix.
There probably is so much money. There probably is so much money that the judiciary will receive. And just so you know, when the Appropriations Subcommittee prioritized our #1 priority, they prioritized $3 million of the $6 million request, and that would still be very welcome. $3 million would still be good.
Great. Any other questions for our state court administrator? Excellent. Then anything from budget, fiscal management, otherwise we discussed at the meeting? No. Liaison.
So Michael will discuss everything when he's here on the agenda.
You've been meeting?
We've had
Awesome.
We're in our busy season right now, and it changes day by day, so it's hard to keep up with it.
Very good. Policy planning?
So we're going to have a long discussion about the 3-judge panel and the local rule, but I just wanted to also update that we've been working on those supplemental rules for each of the districts, and we're still in the process of that. It ended up being more difficult than maybe we thought, but we believe either next month or in April at the latest, we're going to come back with those supplemental rules for each of the districts for the juvenile courts and the district courts.
Bar Commission, Kate.
Good morning. Not too big of a report. We're probably saving that for next month. When everyone's in St. George, we'll have the executive director and the bar president come and talk to the commission or the council. Everybody is focused on legislative stuff right now, as we've previously reported. And then the spring convention is in 2 weeks, starting on March 11th. And so we'll see everyone down here.
Yeah, we're just
Waiting for Mark here.
so
Go
He's
ahead.
not here.
So go to budget.
All right, we're gonna go to budget. We might, depending on the timing, interrupt you at some point to hear.
No. May I get sharing rights, please? Thank you. Thank you, everyone, for giving me the opportunity to talk with you today. Our financial report begins on page 18 of your packet. This is our ongoing turnover savings as of February 3rd, 2026. Our total change this month did go down a little bit. We didn't meet our $65,000 kind of standard in ongoing turnover savings. But in looking at what has happened so far, we're right back on track. I last updated on last Wednesday or Thursday when I was looking at it, and we were already up 50,000, and our benefit differential actually shrunk to negative 65,000 instead of negative 107,000. We will begin reporting that benefit differential in April, so we'll be able to see that when that comes through. Right now, we're anticipating $912,898 in ongoing turnover savings. Again, without the benefit differential, we'll see how that plays out. Any questions about ongoing savings? All right. Let's see how this plays into our commitments that we have set aside. So, as of right now, we have commitments of about $670,000. You can see the available funds right now of $787,898, leaving us with a total of $117,898. That means that we still can proceed with the 8th District Probation Training Coordinator and the Juvenile Court ICJ funding. We are still holding off to see what happens during the session. Like Ron said, it's looking a lot more rosy than we were initially thinking, but we just want to make sure that that money will be available, and we'll initiate those requests, the communications, as soon as the session is over. Any questions about the commitments and reserves? All right, going to our one-time turnover savings. So this is as of pay period ending January 16th, 2026, 1,152 hours. So we're over halfway through the year now. As of that date, we had $1,051,991 of one-time turnover savings. We are still holding our estimate of $900 per pay hour for the remainder of the year. That's $842,400. With that, it looks like we're going to end up at about $1,894,391. This is up from our last report. Looking at this, the increase is due to the fact that we are now incorporating those 30 vacant positions that we've had open for a little bit, when our last report hadn't caught up with those vacant positions. Right now, we are at 27 and a half vacant positions. I know that, and it's been maintaining. It's been going up and down, but it's been about 27 to 30. So we're back up with our vacant positions right now. Any questions about the one-time turnover savings? Okay. Let's see how that plays out with our year-end request. We don't have any year-end requests right now. If we put everything in, we did enter in our operational savings. Right now, that's $539,910 that AOC directors and TCEs have provided to us. I do have an update. We have another, I believe, $50,000 that will be going into that. So that's beneficial. And as of right now, it looks like we'll have about $2,123,000 coming into next fiscal year as carry forward if there are no requests, not including that $50,000 boon to that number that you'll see on next month's report. Any questions about one-time turnover savings or the year-end request? All right.
Next item, Ron has pretty much covered. I just wanted to make you aware that you offered the Appropriations Criminal Justice Committee up to $9 million of revenues. They chose to accept and act on $3.3 million of that. So there's still quite a bit of money that they could dip into should they want to, for sure. They took all of our other recommendations as shown here, except that, of course, none of the payroll-related, human resource-related ones were put into the recommendation, and the $795,000 in two-end justice for all they did not take that. So that's back into, I guess, the budget. So turned out to be really a good exercise. I give credit to our legislative fiscal analyst, Gary Zikas, for listening and working with us. It actually helped us and them to come to a good resolution. None of the amounts we have here, as Ron indicates, impact operations. We have found different ways to use the funds that we get from the court complex, court security, to essentially boost the general funds available without hurting what we need. So,
and I should probably explain one thing that their staff did explain. It's not that the legislative fiscal analyst does not like our staff or does not appreciate their work. Their job is to suggest where there might be an area for cuts, and what they told us was that is where your money is. And so if there's a spot in your budget that's going to be cut, that's going to be personnel, that's actually true. If we had to cut our budget by $9 million, there's just not a way to do that without cutting staff. It's not because the fiscal analyst was eager to see us lose judicial assistance. He was very responsive when we explained to him just how devastating that would be.
any questions about that aspect? Do you?
Oh, we have just a final information only announcement. So we've provided a memo with a status update on the exchange program fee increases that went into effect July 1st of last year. So to give some context, before those fee increases took effect, the exchange program was operating at a significant loss. In fiscal year 2025, we collected around 2.4 million, but our operational costs were over 4 million. So that left us with a deficit gap of over 1.6 million. Looking now at our mid-year actual figures, we're outperforming those original revenue estimates, which were conservative from the outset. And we're currently on track to collect approximately 4.5 million by the end of this fiscal year. So, of course, House Bill 531 comes into play with this. We are limited from collecting more fees than we actually incur in terms of costs to run the program. So we still anticipate, of course, we will remain compliant with House Bill 531. Revenue the projection has increased, but our IT and program expenses are currently projected to be around 4.4 million. So that keeps us within that revenue cushion that we need to maintain. And we virtually eliminated that sizable deficit, that 1.6 million that we saw in the prior fiscal year.
Ron, do you want to mention anything? I don't know where they stand in terms of taking all of these revenues back.
The transparency bill.
House Bill 540.
Yeah, so there are still some pieces of legislation out there that have very large fiscal notes attached. We just don't know what's going to happen yet on those bills. One of those is the one that would require us to live stream either audio only or audio and video. The most recent draft of the bill, I believe, is just audio. Even that has a very large fiscal note attached to it, so it's possible that that could be funded through exchange fees. We would need some additional revenue there as well.
If they don't do it, then Richard.
As far as you know, there were concerned
Yes, it is, absolutely. With
free to somebody.
right, and we, just from a kind of like a fundamental policy standpoint, don't have concerns with that as long as we have the funds to pay for it. It has always been the case, as long as exchange has existed, that there is a user fee component to it. So there is this ongoing discussion about having some portion of that, meaning up to 50 searches, for example, be free to everybody. And if you're going to perform over 50 searches, then there continue to be a fee associated with that. Policy standpoint, no concerns whatsoever. But those first 50 searches for everybody, you have a cost associated with them, and we'd have to pay for this.
Ron, can I just ask one clarifying question? And maybe this is a bad question and I should already know this, but so if you're a user on Exchange and you want to be able to file or do more than just search, can there still be a fee for that? Or so this is a fee for searching, I guess, but are there other fees associated with Exchange for doing more on Exchange than just trying to get a transcript or a video?
Yes, there are fees associated with pulling up individual records, individual findings that are attached to a case. So there are fees associated with that, and those could continue to be in place. Those could actually increase as well. We did just increase those. And that's where the revenue that George was talking about earlier comes from. So yeah, there are still opportunities to make sure that those are offset. It is, I'll say I'm not worried, and we have to be really, really careful about this because there are some things that have yet to be fully funded. So for example, Judge Morton and I were just talking about Senate Bill 134, the bill that created those 7 new judicial vacancies. That's fantastic. We expect that those will be fully funded. That bill was passed before the budget bill was passed. That bill was passed and signed and took effect, and the budget has not yet been finalized. And so we are being very careful to make sure that the $5 million of ongoing funding necessary to implement that bill makes it in there, and the $2 million of one-time funding necessary to implement that bill makes it in there. The timing is a little bit precarious. So I don't know what's going to happen yet with House Bill 540 Transparency Bill. There's some version of that that is likely to pass, and the version of that that passes is probably going to depend in large part on what kinds of funding is available to them. So
Just a question to that. I mean, they haven't funded those new positions, but they will, right? There's no question that that will happen. Or is there a question?
So I'm confident they will be funded. I'm confident they will be funded.
Okay, great. And what happens if they're not?
Chaos.
Okay. Complete and utter, okay?
Because,
They're gonna be
as
funded.
you probably know, the Supreme Court vacancies are noticed right now. And the governor's office is recruiting for those right now. The governor's office has posted it as recruiting for the 3 district court
Yeah,
vacancies.
these are gonna be fun.
Right now. And the notice of vacancies for the Court of Appeals will be posted before the new fiscal year starts. I'm completely confident that they'll be fully funded, for sure.
Is there anything you want to say about phasing out pennies?
Well, the state, who doesn't have the difficulty of having rules and so forth about it, has already gone to a nickel or whatever, which is why round up, round down. But we have a different plan, which has been before the clerk's report. They like it. And so they posted signs that said, please exact change. You don't have exact change, we'll take the check, but it's not going to give you change.
And if you don't know what a check is.
So, that's done.
Are there any questions for our finance folks?
Thank you.
Thank you.
Right, Mark Geary is online with us. He's the item number 7. We're going to take it out of order and hear them now. Mark, the floor is yours.
Thank you. I appreciate this time. I'm appearing on behalf of our presiding judge, Sean Peterson, and our associate presiding judge, Jared Eldridge, both of whom are tied up with very, very large law and motion calendars today that prohibit them from hopping on. So the request that we have before you is the request for to fill the commissioner vacancy in the 4th District Court that's caused by the resignation of Commissioner Marla Snow effective July 1st. Commissioner Snow has happily remarried, and they are in the process of relocating out of state, which is what has necessitated her resignation. In regards to the 4th District Court, it's a very diverse judicial district with a very rural county in Utah, a very urban county in Utah County, a medium-sized rural county in Wasatch, and then 2 other rural counties in Millard and Juab counties. In the request that was submitted, you have the caseload filings by year for each of the commissioners. Very, very high caseloads that we know we would not be able to adequately address without this position being filled. When we submitted this request, we were at a 2.3 in need of 2.3 judicial positions in the judicial weighted caseload report. Even with our new district court judge that was approved, that Ron just was mentioning about, we are still in arrears from a judicial officer standpoint. So we are respectfully asking that the council approve our request to fill Commissioner Snow's position. Are there any questions that any of you might have?
Looks like there's no questions.
I'll make that motion.
Second.
All right, any discussion to the motion? Any abstentions or nay votes? See none in the room nor online. That passes.
Okay. Thank you very much for your time.
We're going to jump ahead to item 8, Court Facilities Planning Committee, Mr. Talbot.
Thank you, Judge. So I come before you on behalf of Judge Christensen Forrester and the Facilities Committee. After review of our committee, our standing committee, we feel that we are duplicating resources and have the potential to disband the committee. I know you're probably feeling some pain from that as a past member, but we feel that, you know, in my last 7 years, as I'm presenting to the committee, it's more giving out information for transparency than actually getting feedback. And there has not been any concern over any of the decisions we've made. And based on the fact that I present to the Judicial Council annually, And I meet with Ron and Nada quarterly to go over facilities issues, and we present to the council as needed. For more urgent issues, we feel that we're duplicating responsibilities here and could really free up those resources and judges' time for other more important issues. So that's what I'm here to propose after our review, is that we disband the committee and move forward with things that we already have in place.
The council will continue to make all final decisions regarding prioritization of facilities.
Require some repealing of a rule to do that or something?
Yeah, we'll have to. It won't be hard. We'll just strike all of that out.
Right, since there's a policy in place. So I guess I'm the guinea pig here. I'm the first committee to come forward and say you could possibly use this process.
This is a momentous occasion.
Get rid of the meeting? It's your great
Is there a prize involved?
So what would the motion be? To
Disband and
repeal the rule and disband the committee?
Yes.
I'll make it.
Second.
Great. We have a motion and a second. Any discussion to it? Any abstentions or nay votes? Seeing none, that passes. Congratulations.
Thank you. I didn't lose any responsibilities, but a little face time with the group. Thank you all.
We're going to go to item 11, Jen Peters, and item 12.
Thank you, Judge. These two items go hand in hand. The memo under tab 8 talks about a request to certify 1 or 2 Justice Court judges. The one that I want to request today is replacing Judge Hazelton down in San Juan County. He also had the Monticello Justice Court. The other one I'll ask to be put on the March agenda for a few weeks from now. That will replace the Judge Dow in Tooele, but he's still winding things down with his current job, so he needs just a few more weeks. So Stephen Whiting is the one who's been selected by San Juan County. He has completed all the online modules and passed the exam for new judge orientation. And so my request would be that he be certified as a new Justice Court judge for San Juan County.
Motion, and I'll second it.
Any discussion of that motion? Any abstentions or nay? Seeing none, that passes.
Thank you. Tab 9 talks about his court. Previously under Judge Hazelton, it was operating separately as the San Juan County Justice Court and the Monticello City Justice Court. Same judge, same courtroom, same clerk, same everything. As far as the public is concerned, it was indistinguishable that one court existed from the other. The city and the county have talked now about combining operations, and they would like to do so. They've entered into an interlocal agreement. And so my request would be that the territorial jurisdiction for San Juan County be expanded to include the city of Monticello effective today, so that when Judge Whiting takes the bench, he's presiding over both the county and the city of Monticello.
I'll make that motion.
Second.
We have a motion and a second. Again, any abstentions or nay votes? Seeing none, that passes.
Okay, thank you very much.
We'll go with Bart.
Morning, Council. Memo in your packet summarizes several updates that we're proposing to be made to Human Resource Policies Manual. We are seeking a March 1st effective date. Hopefully the memo in the packet is helpful so you don't have to go through line by line and figure out what we file as dirty HR changes. But happy to answer any questions that you might have on any of those policy amendments. And if not, we're seeking your approval to have those go into effect
Any questions? Any motions?
Move, to approve the amendments that happen going on March 1st.
Second.
Great. Do I have to call the tie? We're gonna go with Judge Eisman. So, any abstentions or nay votes? Seeing none, that passes.
Quick question for the council. There are a couple of bills going through the legislative session that would require changes in HR policy. Two of those bills have an effective date of May 6th. That would not allow for the time that we usually go through to go to the HR policy review committee, then policy and planning, and then here to the council. And I'm wondering if there might be some room for an expedited process should those bills pass.
Let's skip policy and planning. That's great.
Just ask, put it on the agenda.
Yes, yeah. I was gonna ask, since we have Bart here, if we can maybe have Bart just walk us through one of those bills that has a fairly significant impact on our workforce, but still making its way to the
Yeah, so this bill, Senate Bill 229, would move us away from accruing separate buckets of sick leave and annual leave and move us into accruing paid time off. So this would just be a combined, employees can use that for whatever reason they want. This would decrease the overall leave. When new hires come in right now, they accrue 4 hours of annual, 4 hours of sick. If the bill passes, so that's a total of 8 hours. If the bill passes, it would accrue 6 total hours of PTO each pay period rather than the combined 4, which would be 8. It also would allow for the full amount of PTO to be paid out upon separation. So right now it's only annual leave that can be paid out. And sick leave cannot be paid out. So that would also change.
I'm remembering correctly that it doesn't have the same impact on judges.
That is right. But yes, that's right.
You can't get paid out for anything.
Whatever the case is now, will still be the case for you.
That's right. What do you get paid out for?
Was the end of that.
And there's an interesting one, House Bill 584 that just hit. It would establish an unused sick leave retirement benefit as program 3, paid out at 50%. I saw that one. That's a new one. So we're just watching to see what happens. Another one that will impact employees is postpartum recovery leave. That would increase that. Currently, they're allowed 3 weeks of postpartum recovery leave, and this bill would increase that leave from the current 3 weeks to 9 weeks of leave.
Thank you, Bart. All right, we have our representatives from JPEG here. We invite you to come join us at the table.
Just in time. There's so many time. Internet connection.
I have a few things to say. You have a few things.
Thank you for inviting me here and giving me the opportunity to share a few things that JPEG has been working on. In your packet, I included a summary of some information. In December of 2025, so just last December, we received data, all the data from our surveys that we did. And so I just put together kind of a summary of that data, and I just wanted to highlight a few things for you. We send out our first reports to midterm judges, if any of you are midterm judges, the first week of February using this data. And it was a joy. Oh, good. That's great. That's good.
Certainly guys are proud.
It just appears in the email like a love letter.
Like, exactly like that.
Love letters.
Just a little squeeze. Yeah. we were actually a week late in getting it out, but I'm glad that it's out finally. Yeah, it really did. I would have waited another couple of weeks. You would have been fine. Okay, well, we have been evaluating 139 judges this cycle, and 109 of those receive a survey. So some are at the smaller courts where we just do courtroom observations, intercepting reviews, things like that. So 80, we had a lot of midterm evaluations this cycle. So 81 midterm evaluations we send out at the beginning of February. And then we're still working on 58 retention evaluations, 46 of those that use the survey data. The response rates I thought were good and interesting. This attorney survey response rates were stable between 2023 and 2025. And the court staff response rates are up 5 percentage points. So thank you to all of you for the work you did to try to make sure we got the word out to all the court staff. It really made a difference, and 5 percentage point jump is huge. For the most part, our response rates, you can see, have held steady over the last 4 cycles, which is what we want to see. And we always try to do additional outreach to increase those, but settling in, these response rates are the highest that I've seen in the states that we work with that do surveys. A lot of people struggle with like 10%, 15% response rates, and that gets, judges don't feel great about that. If you can get almost half of people responding, then you feel better that you've got a more representative group of people evaluating performance. I also put some information here on normalization. It's now part of our process, but I know that people are still thinking about it, so I just wanted to let you know what happened with normalization. Almost all of the judges, I think all but one, whose scores were normalized, had a 0.01 point change in their score. There was one judge that had 0.02, and that's exactly what we would expect. And you can see here the averages of district court judges and the impact of normalization, and justice court judges, the impact of normalization. They're all under 0.1. So.
Can I ask a question about that? Do the judges know that you sent these to? Do they see that?
No.
No. Okay.
No, because we sent it last time.
I know, I was in the last one and I did see it, but yeah.
Yeah, just because now it's part of our process, you know.
You're just telling us what the
final score is. If someone called me and asked me, I would tell them. But it doesn't seem to really change much in terms of where you fall. And the average scores are normalized too. So if your score changes by 0.3, the average score changes by 0.6, it all comes out in wash usually. Other questions about the survey data? Okay. The other thing, you ready? The other thing that I invited Maddie. Maddie Klein works on the JPEG team. She is responsible for, she's our business analyst. And so she cares for the data and knows where it all is. She probably knows more about the data than anyone on the team. And she has been working on a project of the last several years that midterm judges saw, which is the judge portal. And so now, instead of a judge receiving a PDF report attached to an email that they get from us, you get to log in directly to the JPEG portal, and you can see your scores, and you can compare them to past years, and you just have more ability to manipulate the data and look at it in different ways. And so it's also better for us, because we don't have to do this manual process of creating a report, which introduces the possibility of errors. So we think it'll be better all the way around. But for those of you who have received a midterm report, you will have seen the judge portal. But for those of you who are not midterm judges, we thought it would be helpful to just show you how it works. So let's see. There we go. Awesome.
Okay. So yes, if you were a midterm judge, you'll have seen this, and then if you were a presiding judge, you'll have seen some of the PDF reports it can produce.
But we have a judge portal now. We still plan to build out a few more aspects of it. But for the main content will be evaluation reports. So there's an evaluation report tab that you can click on. One quirk of the site is if you haven't logged on before, you have to go down and click My Positions before you see positions. That can trip people up. But this little position name with a blue hyperlink is what will show you your evaluation data. What we've released for new evaluations is just the 2028 class year, but if you've had previous evaluations, you can see your 2022 report and so on. So you'll click on that position and then you will get a couple different tabs. So there's a cover sheet that kind of goes over an overview of report outcomes. And at the very bottom here, usually it's just a quote, but if there's any feedback from the commission, you'll also receive any identified themes or issues from the commission there. And then we have our survey responses. So it goes through all the graphs of the different outcomes, your score, peer score, and the same information listed down below. We have adjectives, and then individual survey responses as well that you can look at. So from here, we have survey comments. The nice feature about this is if you want to see if a respondent's left multiple comments, you can click the See All icon and it will list all the comments that person has left. So you can kind of consolidate respondent information that way. Then also if you have more than 5, you can click through and show how many comments are there all at once. Courtroom observations will also be listed with the content analysis, and then the individual courtroom observations will be below that. Public comments, other standards, and we're working to still build this out and make everything as user-friendly as possible. I think for our next feature, what we'll also do when we have 2 cycles ready to go, we'll have a kind of click version where you'll have your retention option and your midterm option, so you kind of toggle back and forth and see how things have been trending. We also have just an overview of the evaluation process for different types of evaluations, as well as some of our processes, so our blind review process, some survey methodology, courtroom observation rubrics that we ask our observers to look at when they make their observation reports, and some other resources, including just our full survey report and some timelines. And FAQs, which I'm hoping to build out when we get some more feedback from judges as well, so how we write narratives. We also are updating our narrative format this year. It'll look a little bit like this for judges that will be on the ballot in 2026, just something where people can glance at it. We've noticed in the paragraph format, how we've had it in the past, people kind of lose themselves in finding distinguishing information. So we've updated that. And then we plan just to do some regular updates on the JPEG process. The legislative session is happening, so we expect some changes as well that we can kind of report out information. But yeah, that's it. I flew through that, but if anyone has any questions or I can go back anywhere. Yeah.
So the public comment category, what's that? How's that different than comments?
So public comments are anyone from the general public can submit feedback on judges. So we have a little form on our website that people can drop down on judges and select. So like litigants can fill it out. Sometimes if there's bigger news stories, we get some public comments that way. But yeah, public comments are just open for general public feedback.
And that's open year-round, every year, right? It's
all day, every day, yeah.
Better tell my mom about that. Get on these one public.
The one thing about public comments that commissioners do is, if, for example, Maddie mentioned there's a really high profile case and a lot of people comment and it's about the case outcome, commissioners won't consider that. So anything that has to do with case outcome, it has to be kind of the process of being a judge, you know, whether you're showing respect to people in the court, things like that. So a lot of public comments are not used.
Do we still, are they still?
Yeah, you'll still see them.
Okay, so we don't.
But you'll know, I mean, I'm telling you so that you know. If it says, you know, this judge ruled against me and it was a miscarriage of justice, commissioners don't consider it common.
But if they were rude to you and ruled against you, you may consider it.
The rude part.
So that, it kind of raises an interesting point where if you get comments from people who weren't involved in the case at all, it's a member of the public who knows about the outcome. How do those get considered?
We have some classifications, so it's like, was this a first person experience? Are you a friend or family? Are other, and a few more. So we can kind of also drill into that information and be like, okay, were you litigants? And like a lot of people self-identify, like I saw this news article, or when I was in court, May 2nd, 2023, and they go, and here's my case number. So it's kind of easy to identify for the most part, what's going on there.
You can tell when there's a news article about a specific case because we'll get more public comments than we usually do. But you see them all. You'll see them. I guess I'll just wrap up by saying that we're still in the evaluation process for retention judges. That will be complete towards the beginning of May, mid to early May. Judges should receive an email that will give them a link to see their evaluation results.
I forgot to say, this print report was broken for a second for midterm judges, but it's fixed now. And you can print your reports if you need one, and that should be fixed for retention as well. So
if you like the old format and you want to print it, I thought you were just making me look at the new format.
It was like, you're gonna log in.
That's funny, sorry. I also thought it was just pure ineptitude on my part. If, as you use it, you have any suggestions or recommendations for how to make it easier to use, we'd love to hear from you.
I am very open to feedback, so please just let me know. Yeah.
That's all we have.
Thank you so much.
Thank you so much. We are ahead of schedule. Shocking. But we're going to jump ahead to our rules. And so we have some rules for final approval, number 14 in our constitutional court rules. Keith, so which one do you want to tackle first?
The rules should be quick. So there were 3 rules back from public comment: 3101, 4410, and 3111. We did get a couple of comments, or one comment on 4410, and Policy and Planning made a minor adjustment to account for that comment, and then provided some clarification on dates, submission dates on 3101. So those are all ready to go for final approval with a May 1st effective date.
So moved. Move that we approve the 3 rules with May 1st effective date. Second.
All right, any discussion? Any abstentions or any nay votes? Seeing none, those pass.
To get them in place.
So now this quick item, the constitutional court.
Right. I don't know, Judge Gardner, do you want to lead out, or do you want me to just?
I'm glad to talk first and let you follow up. So let me start with, we understand that there's going to be a lot of other things we may have to address by rule. In other words, how the court's going to operate. You know, we have deadlines for district court judges. How is that going to affect, the 60-day debt, like other things that are operational. And it wasn't Kisa and I's idea to try to address everything. We're trying to address what we're required to address by March 7th. And so we put together a rule, and Kisa did the laboring order of this and did a great job very quickly. And then we are going to, as required by the statute, prepare a website that will include how we're going to qualify judges and then the list of judges. That did not need to be in the rule, according to the way that the code is written. So we've put in the code, or we put in the rule what we believe we needed to put into the rule. I understand that Shane, that they had the board of district court judges had some feedback about, qualifications, and we can address some of that. But I think from a high level, we decided, hey, let's look at the rule and figure out what we need to put in a rule. And then the rest of it we may address on a website that's going to provide information, if that makes sense. So Kisa's done a really good job of putting together a draft rule. And I guess you've seen her memo and the draft rule. And let me note again here that we were already working on 4-102 because of concerns that were raised earlier. And so when it talks in here about processes approved by the council, we've been working with the presiding judges of each of the districts, and that's the supplemental rule that I've been talking about. Like, they've given us drafts, we've given them feedback. That's going to come before this council either next month or the next month, and that will include, what all the courts have already been doing as far as case assignment and case reassignment. So part of that is going to be addressed in this rule that we were going to wait to pass until we had finalized all of those things, but we're still in the process of finalizing that. But this rule is going to specifically address the 3 judge panels that, and again, there's a lot of concerns from district court judges about 3 judge panels and how they're going to operate, but this rule wasn't meant to address all of those things, just to address, hey, this is what we have to by law provide by March 7th, if that makes sense. I don't know if anyone has questions. Kisa, I don't know if we need to go through any specifics, but I think we can just open it up and see what your feedback is. Again, we tried to turn this around as quickly as we can.
Thoughts, feedback, questions? I'm sure there are thoughts. You don't need to share those. Questions, concerns? Pat?
So it's just a stupid question about the applicability portion. It just says district, juvenile, business, and chancery courts. Are we treating the 3 judge panel as a different kind of court that needs to be added to that as a different court, or is it just fall for the district juvenile? I think it just falls under the district court, but it's a good question. It's a good question. We had already drafted that language before we added the other language, but I feel comfortable with that it's just, we're district court judges. We're just going to be sitting on a 3 judge panel.
And I think it's that third paragraph. I had the same hiccup there for a minute, but I think in the third paragraph, if that's the paragraph you're talking about, 2 more down, it talks about the 3 judge panels.
Sorry.
I think Brody was going to talk about the process, right? And again, a lot of the work being done here is the rule, I think, was more self-explanatory. It's how is this actually going to work is some of the bigger issues.
Thank you. Esme, can I get sharing rights? It's probably easier to kind of demo. So one thing I learned on this, so we won't have the programming in place inside of Chorus until we'll try to expedite as fast as we can. But 1:30. So right now what I've done is I've created basically a standalone application is what I've done, kind of how the logic would work. And I can kind of demo kind of how the logic will work for this group. Please zoom this in a little bit. Okay, so basically how this will work, the way I envision, right now I'm just using test judges as a name. So basically the way I envision the logic works, and I think also you have to approve kind of also the algorithm, how we're doing this. So basically, when I say groups, these are districts. So group 1 is district 1, district 2, district 3. Basically, each of those districts will be loaded with groups of judges. That's how I envision it working, okay? I do have the real judges, but for this scenario, I'm just going to use test judges. And then basically I would save those judges to group. When we go to panel, what it does is the way the logic works, there's two ways it can actually pick the judges. The way I think it should work is it picks random across the 8 districts, which district first. So it's going to say of the 8 districts, pick a district. And what will happen is when it picks that district, so in this scenario, it picked, if we look at the first box, it picked District 7 is what picked first. And then once it picks the district, then it picks a judge within that district. And the reason why I went this route is because if you think about, if we were to throw all the list of judges inside of the selection, because there is more 3rd district judges, we're going to weigh that more. It's like 33% higher likely that it would always pick a 3rd district judge. That was just my thought. And so the larger districts, because every time that goes in the pool, their odds increase. Whereas I thought we should do it at a district level. And then what will happen is after I've selected a judge in the group of 7 district is now pulled out of the pool. Now we select 1 through 6 and 8. And so the next judge that was selected was in 2nd district, then picks random in that 2nd district. It then removes 7th and 2nd, then it picks 6. And so what we've done, I've also given the ability here where if for some reason there was an option where you had to reject and replace, it then removes that judge and then it reselects like you would have moved, like let's say we wanted to reselect for 7th district. That judge that selected decided to recuse themselves. If I hit reject and replace, it then throws that judge out, it removes that, it puts that district back in, and it reselects across the selected districts. That's kind of how that logic will work, and we kind of capture an audit of who has recused themselves, also the ability to actually save the panels as well. So if I can actually save the panels. So that's kind of how the rough logic will work. I know we have to approve this kind of a pre for the March 6th, but then this is what we would also program inside of Chorus as well as the logic and kind of save these historical records.
So I recognize the concern that some of these 3 judge panels then, if we just said, here's all the judges that are qualified judges, and we're going to pick them randomly amongst them, you could theoretically, because there's so many 3rd district judges or 2nd, 4th district judges, you would often find yourself with three judge panels that maybe had 2 3rd district judges.
Well, you can't have 2. You can't have 2 in the same district, but it's highly likely the judges you would almost 2nd, 3rd, and 4th, at least 1 or 2 would be from that. Is what my thoughts were.
And my concern is this is I guess
It's going to be a
overburden or
no question that the smaller districts are going to be overburdened, and even more so if the mega district gets passed. I mean, obviously, but the way that I read this, I agree with Brody that this is how it's supposed to be done. Now, he could change the odds the other way, but you're only going to ever get 1 judge from 1 district. I'm not sure. I mean, this is like a policy decision for us to decide, and this is the first time I'm hearing exactly what he's talking about. And this isn't anything that we've discussed or that we put in the rule. Brody's asking for our feedback, I'm assuming, about whether that's how we want to do it. Do you want?
So you're saying from a statutory perspective, it contemplates overburdening our rural judges?
Yeah. Oh, yeah, for sure. There's no question that it has to, because again, if this new other law passes, more than half the judges will be in 1 district, and this contemplates that you can never have more than 1 judge from a district on a panel. And even as it's set now, again, the districts with less judges, it's set up that way. I don't know how else to say it, but that's what the law is meant to do, is to balance, a judge from different places. And so.
And I would just note that the board is really concerned about the small districts, especially 6, where they have 2 or 3 judges.
Right,
so I just want to put that out there. That was a concern that was really stressed.
So you saw in Keesa's, so we have the rule, and then we have the process by which we have qualified judges. And one of the ways we were trying to account for that is we're saying, look, if you're currently sitting on a panel, then we want to remove you from having to sit on another panel. But the statute says you have to have at least 50% of the district available as a qualified judge. So if you have 2 judges, 1 person gets on a panel, then the other person gets on the panel, well, you got to put 1 back. Like, 1's got to be there. I mean, it's just how the law is written. And so there's nothing we can do to get around it. Now, I think what Brody's asking, and I think Brody's logic, it makes sense, but we could go the other way, which would be you would put all the judges, and you would pick a judge, and then that whole, that whole district would be disqualified. But he's right, if you do it that way, third, second, fourth are gonna almost always be on a panel.
And that's what I thought. That's why I did.
I mean, you would almost never have a panel without.
One of those.
Jeff Lovett, did you have a comment?
Well, just a question on programming. If that mega district bill is still hopping, is that going to be a problem trying to make adjustments in the next week or so and having that ready to go?
So that's where I do have a question, because that mega district, from what I read, this is a little different than districts because they keep the districts intact and then maybe others can chime in, but they call them, and that's why I didn't know, but we could change the programming.
You can do that pretty easily.
Yeah. Well, for this prototype.
Yes.
Yeah.
Yeah, the language of the mega district bill has real problems. And Michael might address it. We talked about it at length on Friday. They could use better language to help us out, and they didn't.
Yeah, I think it's districts. I think we'll have to redo the way I read that bill in conjunction with this.
So even recognizing that going the other direction, picking the judge first and then disqualifying the district, doesn't that lighten you on our rural districts?
It would. It would. Kisa, do you have, this is the first time I'm hearing, again, how Brody's programmed this, and I understand what you're telling us. Kisa, do you have concerns if we went the other way with the programming?
No. I think it's just a policy decision and a workload, but legally speaking, no.
Because
can we just talk through? So the other way would be
you put all the
judges
judges
would be in a
like a
single
ping
pool.
pong ball,
Yeah,
and
you
like
pull out,
you pull it once you got a third district judge,
then
all
third
of them
district-
would be disqualified.
all the third district judges would be removed.
Correct. But the way that Brody is currently programmed it is you've got 9 ping pong balls. You
Right.
pull out a ping pong ball first, and it says a district, and then you're going to pick one of the judges out. I agree completely that if we did all the judges, then it's going to lighten the load on what and let me be clear again, the way that I read this, we don't have to do this by rule. This is instead going to be on the website, and we're going to outline our process. We could always go down a road and then change that a little bit. And as long as the way the law is written is you just can't have, a judge, it has to be a randomized process, which, we'd explain what that randomized process is, but you can't have 3 judges from the same district. Shane, did the board discuss these kind of competing ways to select the judges?
Yes and no. I mean, there was a lot of discussion, but there was no finality or direction that I can maybe go. There's a lot of this is the way it should be done. But the concern of just overbearing small districts.
Recognizing that that's in him, I will say I think I'd probably prefer to go the opposite direction, even recognizing that we would end up with more second, third, and fourth judges on panels. I think selecting the district first gives you a 1 out of 8 chance of it being a rural district. Selecting the judge first limits that in large part, and I want to be clear, this is about burden on our rural judges, especially down in a 6th and 7th district, maybe up in the first where we just got limited judges, and where we will, if they're going to run into what we would normally consider sort of disqualification issues with this 50% rule. And so, as much as I think probably that's programming is easier to pick the district first and then the judge, I'd probably rather pick from all qualified judges than disqualify that district and pick again amongst all the qualified judges. The remaining qualified judges. I think it's very burdensome, but I recognize that that's sort of the policy decision we're making here.
And I think, Shane would echo this from the board, it's just really hard to say how often this is going to happen. And if it happens a lot, then it really would be very burdensome, no question. It's just hard to say. I mean, how often this is going to happen. We're kind of flying in the dark a little bit about.
Every time they're down on points.
But that's going to happen a lot. No, I'm just kidding. I don't know. I mean, it's hard to know. It's hard to know. I can see my caseload and say, well, they could do it in this case, but they might not. I don't know.
And I guess to that end, is there any way we can adjust the workload studies preemptively? I mean, I don't want to wait 3 years to know what the impact. We know reality says that's what'll happen, but I'd like us to maybe try to estimate based on past cases, pending cases, and get an idea of how this is going to affect the judicial workloads as really from the outset if we can. I know that's going to be hard.
Anybody has any idea what this is going to be like?
I'd say at least a year to get it.
The other problem is that, at least from the get-go, the idea of any homogeny and what the cases are going to look like is a huge question mark, right? I mean, you could have a panel case that
I've resolved
is quite beastly, or one that is.
I mean, I've had cases where it could go to a panel where I've literally not held any hearing and granted a motion, and it's
in and out.
You're in and out. It really is. It's hard to tell, and then because we haven't done the process, it's hard to say how much time and how hard it will be to actually, go through all of this, and because there's no, because the statute is clear, there's no venue concerns anymore. The chief is going to have to appoint a presiding judge, and like the location and like how you're going to do things. And district courts, as you all know, are set up very differently than an appellate court, and our calendars are booked out for 8-9 months. I mean, it's not like tomorrow we can say, okay, we're going to have a trial, or we're going to, but we just don't know a lot of the answers to those questions. And that's why I wanted to start this whole discussion by saying there probably will need to be another rule that will go through a lot more about the process. And that's not what we were concerned about on this very quick turnaround, to make sure we have a rule in place about how to get the panel.
I had one question looking at this. It would seem reasonable that the judge who gets the case in the first instance, who should have gotten it randomly, should be able to be the first member of the panel, and then 2 more judges should be selected. Except that in the statute, it says the judge who has the case can not do anything now. But that, I guess that's in the statute, so our rule can't override that, but then you totally lose venue where it was filed.
Yeah, but it says.
I know.
I didn't read it that way.
You need to pick a jury, and so there may be cases in which there's still a jury trial on the panel, right?
Definitely.
And if you have a case that's going to have a jury, then venue does suddenly sprinkle itself back in, because the Constitution also says venue comes from the county in which the case arises, right? So they can stay. Venue doesn't matter. Good start. Maybe it does, maybe it doesn't. I think you're right. I don't think the judge who currently has the case is automatically on the panel. But I don't see anything in here that says that judge should be excluded from the panel. Should be in the randomization.
Yeah, they'd be in the randomization. The likelihood of them re-getting it.
Wait till that small number odds hit.
Yeah, I mean,
but that judge needs to be in the randomization. I think he's entirely right. It has to be judge first. And there was going to be a ton of 3rd, 4th, 2nd district because of the way the numbers work.
Well, you missed this part. Yeah. You came a little bit late, but Brody was telling us he's put together the model right now that you would start with by picking a district. No, okay. And do that. That's not what
that's not random.
That would not be my preference. And like I said, I'm primarily driven by the notion that we could end up with, it would be just as likely then by picking district first to end up with a 1st, 7th, 8th, 1st, 6th, 7th district panel.
I don't think the statute, the way that's written, and we just asked Kisa, and I think she agreed. I don't think we have to do it that way. I think we could do it the other way, or you could pick a judge and then disqualify that whole panel.
Because if we had 4 of these, the other logic would be, since all of the districts are equal in their randomization, the first one would come up 6, 7, 8. The second one, small numbers because we're picking districts first, 6, 7, 8. Third one comes up 6, 7, 8. And now all those judges are doing are these 3 cases. So it does make sense. You got to go by where the randomly assigning judges, then you should be picking from judges, not randomly assigning by district.
I actually agree. I'm not pushing back at all. I think Brody just was picking away. This is the first time we've discussed this.
Oh, understood. And I knew what comment.
Does anyone have any concerns? I mean, do we?
Yeah, I just had to put a prototype together Friday. They're like, Friday, can you get us something?
Yeah, it was literally like
very quickly. Since you need this in 2 weeks.
I mean, I'm looking at the code again, and I think for sure randomized panels, we can start by picking judges and then disqualifying that district and then picking another judge and disqualifying.
And we should always see a third. I'm guessing every panel is going to probably have a third or a second or fourth just because of probability.
But what we're talking about, that's what we ought to do. Yeah.
Yeah.
Because again, the way that we've written that is that judge then, once they have one, won't get another one. But in the big districts, you'll never get another one because we'll always have 50% available unless, the numbers of these are just way crazy. But it doesn't work the same for those rural districts.
No, and that's something we got to figure out too, because like in the rural, let's say a judge gets selected in 6th district and there's only 2 judges. As soon as that judge is picked, does that mean that they're below? They're at 50%.
They can't be below.
So they can't be below.
Yeah. So the other judge would be the only person, but they would be in this randomized process. But
it's less likely they get selected.
But your lottery odds increase when you're in a smaller district for sure, because once the bigger district gets selected, then that district's taken out of play.
30 judges are out of play.
Yeah, I mean, there's no question the judges in the rural districts are going to get on these panels more often.
Yeah, it's going to be disproportionate either one of these 2 rubrics that we pick, but one I think is
way
less burdensome.
Yeah.
Well, and I think we need to assume that, one judge in the 7th district could have 2 cases at the same time. I know we want to try to give them one and then get them out, but
for sure,
we may have 4 cases going and somehow the randomized process puts, all of them in the 7th district, for example.
Correct.
Yeah, I mean, there's no question that could happen. And again, if the mega district gets created, even more so, like it would even, because you'd have half the judiciary, half the district court judges in one district. So
that would change things drastically.
Yeah,
So the proposed language calls them districts for the sub-districts are also identified as districts. So you can still use the same districts.
It has divisions and districts.
And that's why I was saying
most of those divisions, districts.
Yeah, it does currently use the word district, I don't know, twice for 2.
Well, I think it keeps that for administrative purposes, because that's what we've said, hey, we need to be able to administer these in the way that we have. I don't know that it translates to the language of the 3-judge panel statute in terms of keeping it like it is now.
I'm assuming all of this is going to be challenged somewhere, although the statute says you can't challenge the.
Okay. You can't appeal.
Well, it's not subject to judicial review, the request to put it into a panel, but.
Oh, in liaison committee, we talked at length about Marbury versus Madison.
Careful.
Yeah.
All right, so it sounds like this council agrees that thank you for your efforts. Go with the other idea.
Not a problem.
Your rule regarding this has to be in place before March 7th.
Right.
Yeah.
But we're not putting the
randomized part in the rule.
The rule is already, Lisa's already done that. And then the randomizer, we'll just explain that on the website.
And I think we keep pieces, the draft rule has it go into effect on March 6th, and I think we keep that date. That gives us, we don't put it into effect today.
But we pass it today to
go into effect on March 6th. That gives us a little bit of like, what did we say?
A motion?
Yeah.
So motion, I think it's a motion to approve the draft 412. All right.
Yep.
Any discussion to that motion? Any abstentions or nay votes? That passes. Associated or in our packet, we are also showing a bunch of the rules of procedure. I assume the Supreme Court's doing their thing in that. We're all looking at you.
Which ones are you talking about?
The ones that are contained in SJR 5.
Yeah, I mean, they've been passed.
Yeah.
It's just on.
So let me just bring up one other point then. We have to establish and maintain a list of judges who the Judicial Council determines are qualified to serve on a panel. That again, we're not putting in the rule. But Keith and I discussed a couple different concepts and they're in those bullet points below. And this is where the council would, we'd have to decide, hey, is this a qualified judge? So presumably every district court judge is qualified. We wondered if we should not put a new judge on the panel until they've been a judge for 6 months. My understanding is the board had some concerns with that, Shane. I mean, and this was just Lisa and I brainstorming about what could we possibly do. To the Board of District Court Judges, my feedback from someone on the board was that they did not want to keep out a new judge from being put on a panel.
That's what the board talked about for new judges.
Yeah, I could see it either way. I mean,
Did they want only new judges and all the ones who are on the board to have exceptions? Just checking.
And I raise it because, becoming a judge can be really difficult. You're learning a whole new thing and then you get put on a panel, but I could see it either way.
And the other two judges for you on the panel.
The other issue is we've talked about the rural districts. A new judge on a rural district would be 50 to.
Yeah, if there's 2 judges and you got a new judge, they still wouldn't be there. The other person would be because you'd have 50. Right. Yeah. But I'm not sure which way to go on that. We could do 3 months, we could do nothing, and we can always change this because this isn't going to be in the rule, but it's going to be on the website about how we're qualifying.
Given the reality of the fact that we have 2 judge districts, I don't think we can almost do any disqualifications of judges.
Well, I mean, unless both judges would have to leave at the same time, as long as there was 6 months, you'd always have one from that district. And again, they'd have to stay qualified even if they got a case until the other judge had been up to speed for 6 months. We definitely could do it, but we don't have to. I mean, Keith and I sat down and tried to think of things that we could do that the council may want to consider. I don't feel strongly, I don't think Keith feels strongly about, do we want to keep new judges away from this for 6 months, or do we say forget it? Like, let's just, everyone's qualified.
I don't want to feed into the idea that every single district court judge is not qualified, because that's what's emanating from the legislature, and I don't want to feed into that. I also don't want to give anybody the idea that we're keeping some judge from being involved because they have this assumption that judges are selecting their cases. And so I think that we should say, if you're a district court judge, we believe you're qualified. That's been our position the whole time, and why we don't think the 3-judge panel has been necessary. And I think that and it stinks if you're a brand new judge and you have to get baptized by fire, but I think that's the way it's got to go.
Is there anything else that a district court judge is?
We've got 4 bullet points.
From?
We said, hey, if you've been,
there's a couple things.
you would be removed from the list during periods of disability or administrative leave. That one seemed to make sense. We have one here that deals with retirement. Hey, if you're going to say you're going to retire, we don't want to put you on a panel that's going to, that's an appellate court kind of thing. Yeah, that one seems to make sense to me. So once you've announced your retirement, you don't want to be picked on a panel. That would, seem to make sense. And then the last one is, we said, provided it would not violate the 50% rule, district court judges actively sitting on a panel shouldn't be on another panel. And that one seemed to make sense too. We want to spread this out. But otherwise everyone would be qualified. So you could maybe think of more reasons why someone wouldn't be, but it had nothing to do with anything other than those 4 things that Keith and I discussed.
And then the other one would be just general rule 63. I deal with rule 29 more than, I don't deal with 63, but 63 is just qualifications of the judge. If the judge makes a personal determination.
Yeah, but we're just maintaining the list. Right. And so they can,
but we might have both judges in the 6th might go, nope. And then our new randomization is not going to have 50% of the judges in the district, but so be it, because they would have been there except for their personal disqualifications.
Well, but I'm.
Oh, no, I'm
I see what you're saying. But what I'm saying is if they disqualify, it's going to be on a case by case basis. Yeah. No one, I don't think, can just disqualify from being on the list.
Correct.
Right?
Yeah,
or
I was, no, I think you're right.
That they remain on the list, but if they come back to them, they just disqualified, and it just go through the randomization.
Yeah, it would go through the randomization. So,
and the fact that the randomization will now, this randomization for this case will now not have 50% representation for each district is so be it, because the judges are disqualified.
Yeah.
Cool.
I mean, theoretically, they aren't disqualified from that level.
Right.
Lisa, did you have a comment?
Statute says we have to have 50% on the list.
Okay.
So,
yeah.
So
talk about maintaining the list. There you go. That's great, Lisa.
Yeah, this is so Friday night.
Is there a consensus that we say, hey, forget about the 6-month rule, but the rest of these, they seem to make sense? And then as we go forward, we can always adjust this. Like, let's say we decide, hey, we look at the data in a year and there's only been 2 of these and it's, but they're really big cases. And we say, yeah, we don't need a new judge. We don't need them. Like it's, we can isolate them. Or we see that there's hundreds of them and we're like, yeah, we need all hands on deck. You become a judge, you're qualified. Like, you go and you sit on a calendar from the very beginning. And that's what we do.
Is that the consensus of the group? Anybody want to speak against that?
So summarize the consensus. What are the specifics?
One specific is the randomization is what Brody has outlined, but the flip of it, right? That we're going.
We're going to pick judge first and then disqualified districts.
And then disqualified districts. The second is as to the 4 bullet points, we're rejecting that new judges get a pass. And the other 3 bullet points we are adopting. Number 1, that a district judge would not be eligible for a panel during periods of disability or administrative leave. Number 2, that if you've announced your retirement, then you're disqualified from being on the panels. And number 3, that we've already mentioned, if you've been selected for a panel, then you'll be taken out on the next.
Subject to the 50%.
Subject, yeah. That is the consensus. Do you have a question, Brody?
No, I already made changes to the panel and I just ran like 2 or 3 versions of it. And first time it selected two judges from, it's like Judge Garner.
It doesn't sound random, but
so first time it did 4th and 3rd were the 2 first districts, and then it picked a 6th. Second time it did 2nd, 3rd, and 4th, which would make sense. It's you're going to see those more often.
Yeah.
All right.
So
I don't see any.
We have to make a motion on this. Like, what's the?
I think we should make a motion because the statute directs us to do something, and so I think we should.
So I will move that we adopt the judge first, then district randomization and bullet point, and just the only disqualifications from the panel would be bullet points 2, 3, and 4.
Second.
And the rule. Effective March.
We already did
the rule.
Okay.
Any questions about the motion? Any discussion to the motion? Any abstentions or nay votes? Seeing none, that passes. Good luck, Brody.
Yeah, good luck.
Thanks, Brody. Thank you, Brody.
Hey, now is the time scheduled for a break. I want to be sensitive to Mr. Drexler. Are you good? We'll take a 10-minute break. We'll reconvene at 10:40.
We like a break.
That would be because you could just like Mr. Drexler is going to be called before. Before we turn the time over to Mr. Drexler's
Fly the Clyde.
Follow up on. The first is that we had a presentation from JPEC today, and they talked about the midterm reports having to give to the judges. There is a function for the council to perform, and I believe Ron will be sending all of the reports to council members
Today. Today.
What we're looking for there, that is not something for you to share further. It is still confidential information, but what the function that the council performs is obviously presiding judges are out there and they get to see these reports as it pertains to other members of their respective benches. And they can then reach out in a mentoring capacity if there's something to do there, or otherwise be a sounding board. But what they can't see and what the council alone can see is the totality of the reports. And if we were to proceed, early on, this was a much bigger issue. We then would go to JPEC with specific concerns saying, we don't like your entire global approach to this and this. That seems to be far less of an issue now. But as you noted maybe today, they said, hey, we're doing this, a different thing with our narratives. It's always couched as better, but better can be in the eye of the beholder. And so what we need you to do as a council is to look at these reports and then come back and, if needed, raise the issue that if you see something globally in an approach sense sort of way with these reports and their approach, then you need to bring that back to us. Because we as a group are the only ones that see them collectively. And you'll get the same thing when the final reports go to those who are standing for retention. So you're going to receive that today. It's a lot of reading. And so and a lot of it's just pats on the back. Yeah, that judge is doing great. Yeah, they're doing great. But we want to go look at those narratives specific, since they've told us they're doing a new thing. Let's make sure anytime they do something new that we have eyes on. The second thing is just a reminder to anybody on management is we have a management meeting immediately following this meeting. We do have some things to discuss there, so make sure you stick around.
Can I go back on that JPEG?
Sure.
The public comment thing, that's new too, isn't it?
It's not, and just so you know, the one thing they kind of left out of the discussion is the public comments never go public.
Okay.
The comments from
It's just the way it was so dismissive that, oh, don't worry, they won't look at that.
That's not new.
I bet they will.
No, they do look at that, but they're not supposed to take into account anything that's result quality. So that's actually not a new function. And we always have concerns when we hear about that's going to somehow make it, into the JPEG matrix and then out to the public. That does not happen. So.
And again, my apologies for not having, if they covered it, great. And again, because I'm also a presiding judge, so I've got a little slice of these. It does seem that in my slice of the world, the average numbers have crept down. Do we know if that's true across the universe of judges across? Because I had talked with them and they didn't address in terms of numbers, roles, scale, or where things were falling.
We can bring them up in the future.
No worries.
I do know.
We were going to get them all to be able to look at.
Yeah.
The comment I got, because I talked to Marion Lambert, was, seems like people are grading harder than they used to.
That may be true. I do know that statistically, the longer you're on the bench, the more your numbers go down.
Yeah. Yeah. It's just because you switched courts.
Yeah.
Yeah. So, all right, Michael. Thanks. The first item, you have two things.
Yeah, item 9 on the agenda. Should we do that?
Uniform Fine Committee.
Thank you. It's nice to be with you, friends. Item 9 on the agenda, tab 7 of the materials, is a request for 4 action items from the council. One is to approve changes to Rule 1205. That's the membership of committees rule, particularly as it relates to members of the Uniform Fine Committee, changing it from 8 members to 3 members. Currently, it's 4 district court judges and 4 justice court judges. This would change it to 1 district court judge and 2 justice court judges. You've heard this before it was authorized to go out for public comment. It went out for public comment, didn't get any comments, and now it's back before you for hopefully final adoption. If you make that change, or even if you don't, currently the Uniform Fine Committee is without a chair, and the council designates the chair of these committees, and the request is that you appoint Judge Porter as the chair of the committee, and then there's some membership issues that need attention, including the reappointment of Judge Finlinson, a Justice Court judge, for a 2nd term on the committee, as well as appointing Judge Sessions as a 1st term. And the process for identifying how Judge Sessions was selected is outlined in the memo. I'm happy to answer any questions that you may have.
I move to do all those things.
And I will second all those things.
Any discussion as to all those things?
Is anybody unclear about what all those things was?
Do you want to restate them?
No, I could, but I don't want to.
Okay. All right. Any abstentions or nay votes? All 4 things pass.
Perfect. We'll be back before you in April or May with a bunch of changes to the fine schedule when we do the implementation post session. So we'll see you soon on that. Move to item
10. Legislative update.
Legislative update.
Is anything going on?
Well, it's been a slow now. How are you all holding up? I hope you're doing well. I wanted to start by asking a question. In years past, I have prepared a list of bills and tried to include that in the meeting materials. Would that be helpful in the future? I was thinking about it last night and I thought, oh, I've come the last few times to just have a discussion with you about pending matters. Would you like a list of bills, council members, to kind of sink your teeth into? I want to do what's helpful to you, so I was hoping for some guidance there.
I think it depends on how fast it's moving and whether you're able to, because I have in liaison, I've tried to keep a running chart. I can't keep up with my running chart because bills are getting combined, and so if it's possible and timely, great. But if you're not able to because it's moving so fast,
I agree. I find it incredibly helpful to have a list of bills, and at the same time, I'd rather you spend your time in more effective ways if you don't have time to show me.
Yeah.
That's helpful. Any other feedback for me on that?
You have a sense of what bills are very, very likely to go forward and which maybe are less likely, so we just have to trust you on that.
Yeah.
Oh, I appreciate that. Thank you. Okay, if you change your minds, you think this isn't workable, especially after our conversation today, and you think, oh, it would really be nice if we had a list of these things, I'm happy to do more lifting next. Let's talk about a few categories of things. Oh, before I do, any specific bills that anyone has questions on, I'm happy to take those at any point. Just interrupt me. But I had a few categories of bills that I wanted to
the jury selection bill, the Senate joint resolution.
Yeah, I've got that on my list. You want to talk about that right out of the gate?
And the GAL bill.
Thank you. I've got that on the list as well. Okay, so let's talk about there are 4 bills. Well, let's talk about it this way. There are 2 bills that lean heavily on the administration of the judiciary in terms of how juries are selected. That's Senate Joint Resolution 10, and it proposes an amendment to the rule of criminal procedure about jury selection. It feels, though, administrative, not necessarily procedural, because it really is designed to undo the decision-making of presiding judges, at least as it relates to the 3rd District's implementation of virtual jury selection, which, anyway, so Senate Joint Resolution 10 would propose that jury selection in a felony case be in person unless the parties agree. And if the parties all agree that it can be virtual, then it can be virtual. In 3rd District, that is not a workable model. Given the volume, we don't have 2 parallel processes running where people can elect one or the other, especially kind of in an ad hoc sort of last minute sort of way. I know that there are discussions that have been had among some of the stakeholders in the defense bar, prosecutors, and some of the involved judges, the presiding judge, and yet I don't know if those conversations have resulted in anything meaningful that the sponsor, which is Senator Patel, is willing to buy off on. So it's an ongoing conversation, and I'm not sure where it stands, but it does feel more than just rule of procedure. It feels administrative. And so there's a challenge there. I can tell you, just so you know, that the primary concern is that there's this belief that wells up from inside of people that the only pure way to select a jury is to sit in the same room with them, breathe the same air, and kind of look right into the whites of their eyes and see them in real time, in person. I've heard from judges, and maybe you are some of those judges who have done both, that there are real benefits to doing a virtual selection process, and it may come with some trade-offs, but not the sort of trade-offs that would compromise the validity of any resulting jury decision, whether acquittal or conviction. So I don't know. Any questions about it? Right now it stands, it's still in the Senate. It hasn't moved out of the Senate floor yet. It's been through Senate committee. Let me check to make sure that
No, it's still there. That's why I was asking about it. It's been sitting for a while.
All of the legislation has been on calendars in their respective houses for some time. The general word in the legislative hallways is that bills have stacked up on the second and third reading calendars in ways that they normally haven't. 2 weeks ago, in both chambers of the legislature, the Senate President and Speaker House said, hey, we've got to move a little more expeditiously on these things because we've got a bunch of work to get to. So part of it is just they talk about poor backlogs. Maybe there's a little bit of a legislative backlog on processing bills through the floors. We're continuing that conversation though, and there's certainly, I think, some willingness to consider some alternatives to the status quo, at least as I've heard in the 3rd district, if it helps to not have Senate Joint Resolution 10 be the state of the law. And I guess if it's completely unworkable, it's a rule of procedure that can be changed. Okay. In combination with that, and then we'll talk about the Guardian Vita bill, since there was a question specifically about that. There's another bill that leans heavily on the administration of the judiciary, and that's House Bill 366. This is a bill that originates out of a challenge, I think, that has existed primarily in 3rd district, although as I've learned more, it's also a thing for 4th district in particular. This is about the way in which municipalities are able to prosecute their cases in district court. And there's a few categories of cases that happens in, right? There's the de novo appeals from your regular old run-of-the-mill Class C and Class B misdemeanor. There's domestic violence transfers that come, cases that move from the justice court to district court for trial. There's some direct filing of Class Bs and Cs in certain district court locations because there's not a county justice court or there's a holdover from the old circuit courts. And then there's the municipalities who elect to prosecute their own Class A misdemeanors in district court instead of having the county or district attorney do that. And in 3rd and 4th district, a number of municipalities were electing to prosecute their own Class A's, in addition to all those other categories where they had to be in district court. In 4th district, it worked pretty well for a long time to have those municipal calendars being heard in district court on a consolidated calendar because we had the American Fork location. And Judge Porter and Judge Griffin were already doing a lot of misdemeanor work because it was a holdover site from the circuit courts, right? And so it was efficient and smart, I think, to have those cases be heard with all the other municipal cases and done that way. When that court location closed in 2024, 2025, and Judge Griffin and Judge Porter returned to the Provo courthouse when we were evicted from American Fork, the decision was made by the presiding judge to spread those misdemeanor cases among the district court judges so that if you're in the Provo courthouse prosecuting criminal cases, whether you're the county or a municipality, you're kind of on the same calendars and there's no preferential treatment to the cities to have expedited or special calendars. Similar sort of change was made, although for very different reasons. I think in 3rd district, historically West Valley City has prosecuted their own Class A misdemeanors, and they do so to the tune of around 1,000 cases per year. Compare that to any of the cities in Utah County where they were doing maybe 100, 200, 300 cases per year. So it's a significant amount of work for a single judge or 2 judges or 3 judges in 3rd district to take on. So a decision was made after a lot of careful consideration and conversation over the course of several years to phase those West Valley City calendars out to be generally distributed among all the judges in the district, both at West Jordan and Addison. And that caused West Valley City to be particularly frustrated, and I think understandably so, although I think I understand their frustration. I don't know that they fully understand the challenges that we have expressed in terms of why the decision was made. At least it hasn't felt like there's been that level of understanding. Because of those changes, West Valley City contacted Representative Tusher. He's the representative from South Jordan, and asked if he would run House Bill 366 that would require the presiding judge to assign municipal cases to a subset of judges, no more than 500 cases per judge, and in the geographical location that is most closely approximate to the city that is being prosecuted in that case. So it's really, from my point of view, really micromanaging the judiciary and substituting if it were to pass, substituting legislative judgment for council judgment. And the Constitution obviously leaves the administration of the judiciary to the council, and the council has created the rule that allows presiding judges to make these sort of decisions. So it's a challenging bill, I think, on principle, and it's a challenging bill in execution. And we're still having conversations about it. In fact, I know tomorrow there's a conversation between Judge Mao and Judge Pettit as presiding judge and associate presiding judge in the third with West Valley City to see if there's something that could be done to alleviate some of the concerns and keep the legislation from moving forward. We have identified a solution for a potential solution with the involvement of Judge Mao. For all of the cities that aren't West Valley City, the lower volume have to be in district court, lower level misdemeanor city prosecutions. We floated that to the other cities in Salt Lake County, and they flatly rejected it. I think I may have offended them in the way that it was worded, because it did come with there's a monetary component to pivoting our systems, and we don't have that money. And in a meeting, one of the cities said, I would much rather contribute to a technological solution than be running around to multiple courtrooms and courthouses. And we leaned into that a little bit. Maybe we were wrong to do so, but they said, we're not interested, cities, I think, said generally, we're not interested in paying to fix a problem that the courts have created. But they haven't come back to us with a counteroffer. So currently, I don't know where things stand with all of those other municipalities, but we are continuing conversations to see if we can get that sorted out. Any questions on those too? We'll try to figure it out, all the fun things, right? We'll pivot to Judge Eisenman's question on House Bill 372. This is a bill that in its first iteration just seemed to make a number of innocuous changes about juvenile court judges paying particular attention to particular sections of code when they're making certain decisions. The second substitute of the bill proposed what felt like a wholesale restructuring of the way in which guardian ad litem attorneys and private guardian ad litem attorneys would function in juvenile court and district court. It would change the model of representation in the second substitute. Would have changed the model of representation from the best interests of the child as the guiding star for a guardian ad litem to advocate for, to the express wishes of a child who was 8 or older. And if you were younger than 8, then you would still advocate for best interests of that model. It also would have done a number of other things. I can tell you though, preview of what I'm going to say in 2 seconds, that version of the bill has been substituted. So these things are no longer mostly relevant. It would also have required the guardian ad litem attorney to record all of their interactions with their client and then retain that so that if the judge ever needed to review that in camera, it would be available for judicial review. Restructures a little bit the guardian ad litem oversight committee, adding legislators to the committee, one House member and one member of the Senate. It does a number of other things. Let me tell you though where it's gone since that second substitute, which was 2 weeks ago now. There's a third and a fourth substitute. The fourth substitute is the one that is presently adopted, and the other thing is the initial versions of the bill would have limited the juvenile court to appointing a guardian ad litem attorney in only removal cases, not cases where the child's remained in the home. The fourth substitute does away with that change so that a judge in juvenile court can still appoint a guardian ad litem attorney in any case. And that's partly because there's a lot of federal funding in the mix for having that ability. So there's that part. It takes private guardian ad litem attorney completely out of the bill with a recognition that the dynamic is different in district court when you have parent, and kids, as opposed to parent, DCFS and the Attorney General's office and kid. And so I think you might gather from that there's some concern about potential alignment between DCFS and guardian ad litem attorneys, where it feels like the state is stacking the cards against the parents in some context or in some regard. I don't know if that's how it plays out in practice, but I think that's one of the concerns that is prompting the legislation generally. And because that concern doesn't exist with the private guardian ad litem attorney model or context in district court, they were having to take that part out. They've taken out the part about recording the interviews or the interactions. So there wouldn't be any concern about attorney-client privilege in this version of the bill. And they've also raised the age limit for whether it's the model of express wishes or the model of best interest to 12 or older, with a provision that also recognizes that if a guardian ad litem attorney disagrees with their client's expressed wishes, that guardian ad litem should explain that disagreement to the court. So it kind of preserves where we are, but it kind of flips it a little bit upside down. Instead of saying advocate for the best interest, but also communicate your client's wishes, it says if they're 12 or older, communicate your client's wishes, but then tell the court that you disagree if you disagree that their wishes are the thing that you have to report. Judge Levitt has looked at this really closely from liaison committee since he's the juvenile court judge member. I don't know if he has anything he wanted to add, but it feels like it's in a much better place than it was in the second substitute, and in the second or the first substitute. Anyway, I'm losing track. It feels like it's in a better place, and I think liaison on Friday's meeting voted to take no position or remain neutral on this version of the bill. Any questions about that?
So the way it is now, it's not going to affect the jail's federal funding, you don't think?
It doesn't look like it would because it makes no change to that provision. They can appoint in PSS or removal cases and the other context, the conflict or the private guardian is out of the bill completely, so that remains unchanged. Any other questions on that one? Okay. There's a number of bills that I think are deeply concerning to all of us for, I think, really understandable reasons that have not moved at all. They got numbered and they haven't moved an inch, not 1 inch. I'll tell you what those were. House Bill 262. It's a repeat of House Bill 451 from last session. It's Representative Kyle's ability to change the quantum of retention votes from 50 to 67%. It got numbered and it hasn't. House Joint Resolution 13 is Representative Brooks' proposed change to the Utah Constitution, which would allow the legislature to create special retention elections on a per judge case if they felt like the judge wasn't making the right decisions in the right way, conducting themselves in the right way. That also has been numbered, but just has not moved an inch. There are two pieces of legislation that need to be read in harmony with each other. House Bill 424 and House Joint Resolution 5. These also both belong to Representative Kyle. They would make nominating commissions optional for the governor. The governor wouldn't have to use a nominating commission, but could.
And that's a proposed constitutional amendment, right?
That's why there's the House Joint Resolution 5 component of it, is because there needs to be that constitutional change, and then there's some statutory changes that would accompany that in House Bill 424. But those also numbered and haven't moved an inch. And I have reason to believe that they likely won't move, and unless it's always possible that these things can move. So I guess depending on how the next 2 weeks go. The other part of it in House Bill 424 and House Joint Resolution 5 about optional nominating commissions moves the Chief Justice's ability to appoint if the governor fails to act on making an appointment through the governor's legal responsibilities. So what could happen is you could have a vacancy if both those pass. You could have a vacancy. The governor could or could not, doesn't matter. It's up to the governor, have a nominating commission, and then just not appoint anybody to fill the vacancy. And then Chief Justice's ability to step in and say, you didn't act in the requisite time period, now I'm acting. It would just remain open, unfillable. So that's what hangs in the balance. There are other two bills that talk about judicial retention or selection that I think probably are still going to move. Senate Bill 233 is Judicial Performance Evaluation Commission amendments. This is Senator Brammer's bill. It's still on the Senate's second reading calendar, but I think he intends to move the bill. This makes a number of changes to some of JPEC's processes, but the biggest change I think for our perspective is it puts your rule 3101 about cases under advisement and how long appellate court, in particular, portion of that rule that talks about appellate court opinions and the timeline for issuing those opinions. takes that rule and puts it word for word basically into statute. And those case processing timelines have never existed in statute. And for good reason. They are administrative, talk about how judges ought to be moving cases along. Senator Brammer's view of it is that we can administer the judiciary how we would like, and they can dial in on the performance metrics for JPEG that they would like. And so there's an interesting tension that exists there. As long as the statute and the rule mirror each other, there's probably not a lot of room for conflict. But when one changes to either something that's